Hi, everyone. Thanks for joining us today and welcome back to the Bulletin podcast. I'm your host, Charina Garcia, and I'm here with WR's Director of Visa Consulting, Charlie Oppenheim. We're going to recap the June Visa Bulletin and talk about what it means for HR, immigration, global mobility folks. And we're going to address all your Q&A questions that we've received. Before we dive in, this is our Q&A podcast. So if you have any future questions that you want to ask, go ahead and put them in the comment section. We also do consultations with specific industries. Like one of the consultations Charlie and I did was for the Schedule A healthcare nursing industry and his specific predictions for that industry. So if you have any requests for anything like that, please feel free to reach out as well. And with that, we'll dive into the questions. So Charlie, what are your predictions of any changes in the EB3 China category in the next 12 months?
I think that the China, during the course of the next months, that the China employment third preference should advance through the remainder of the year up to 3 weeks per month, possibly as there was the case for June. Actually, none of the China dates advanced for June, but for third preference, I've been predicting up to 3 weeks, which means no movement up to a maximum of 3 weeks. So for China going forward, there should be movement, especially during the course of the next year.
Okay, so we'll see more movement in the upcoming October.
Right, and part of the reason there hasn't been much movement in China or India is we're starting to near the end of the fiscal year, so numbers would be running out. Come October, there will be the new annual limit, so that should allow for some forward movement of the final action dates.
Okay. And then, there's some questions here about the domestic visa renewal pilot program. The Department of State rolled that out this year. So, before, everything that happened in 2001, right? September, the attacks. During that time period, we were allowed to actually have our clients send us their passports and they would want to renew their H-1B visa stamps. And so we would just actually send it to Department of State in Washington, D.C., send photos, complete the DS-160, pay the fee, and then the passports would actually be returned to us in our office. And then this helped employees because then they didn't have to worry about making a visa appointment, being interviewed overseas. But after September 11, of course, all of that changed. And so it's only recently in the past few months that they've rolled out a new domestic pilot program. We're not sure yet how and what's going to happen with that pilot program. It was a very limiting program in terms of they're only accepting people who met certain criteria. So we'll have to see. So just stay tuned to that. But Charlie, from your recollection, anything that you've done in state, do you have any idea of whether you think state would actually roll that back out, the visa revalidation renewal program in the U.S.?
I think there's a distinct possibility that they would. It's not only makes it more convenient for the applicants, it also helps reduce the workload at overseas posts for potentially unnecessary visa interviews occurring. And if the work can be done here in the States, again, for certain categories. So I think the fact that they've announced this is a very encouraging step, and that hopefully that as they do this, they will find that, yes, it is something that we can maybe expand upon a little bit further. Hopefully they could get back to all the categories that they would do, as you mentioned, pre-2001.
So do they just, because it's going to be stateside, so is it basically people who've rolled out of their consular post assignments and they're relocating back to DC, and these are the folks that are actually processing the applications, or they train a whole new team of people on how to do visa renewals?
Often it's a lot of the Foreign Service officers often have spouses, and often the spouses would be working in some capacity at the embassy or consulate, and that are able to do this type of preliminary processing, doing a lot of the background information. For example, the equivalent of, say, a paralegal with a law firm. So the spouses are very knowledgeable. And therefore, when the spouse, the husband or wife, the Foreign Service officer, moves back for assignment in the Washington area, the spouse is there. The spouse may be looking for employment, or so therefore they have a quote ready-made pool of potential adjudicators that could help out in pre-adjudicating these cases, or they could get the staff that is on board there at the visa office to be adjudicating the cases, as was done previously prior to 2001 when the changes were made. But again, they do have, options available to them, and the State Department is very good at trying to maximize the potential for processing and again, it is in their benefit to try to do some of these cases if they can be processed over here. It saves the processing time overseas and allows overseas processing to occur in other areas, reducing workload.
Well, yeah, and with all the other security enhancements, they're utilizing AI. You would think that from the onset, they had to go to the embassy typically or consulate for an interview. So hopefully all of that's been vetted so we could kind of streamline and make it more efficient here for people and reduce the workload at the post overseas. So other questions that we're hearing a lot about is the national interest waiver, alternative green card option for Indian and Chinese nationals who are stuck in the backlog. How do we assess employees for this option? We've actually created a whole PowerPoint and a whole process here at our office on how we conduct assessments for national interest waivers. First of all, we determine, do you qualify, meaning you have a master's degree or a bachelor's and 5 years of work experience. If you do, then the EB2 NIW should work for you. If you don't, then we look at the third criteria, which is exceptional ability, because we do some individuals who are straight bachelor's degree graduates. And so we'll look at that criteria. The next thing we look at is what industry are you in? Because if you look at President Biden's executive order, he's trying to encourage, the approvals of NIWs for those in the artificial intelligence or AI industry. We're also finding a lot of approvals coming through in the semiconductor, lots of different industries as well. And so we'll assess that too. And then from there, we determine how much documentation needs to be submitted. Has the person been cited, have any publication, judge the work of others, and looking at all that criteria, what original contributions have they made, any patents that they have. And what we've done in our office is actually, if we were normally looking at PERM, we're actually looking at NIW first and then assessing that first. And then if they don't qualify, then doing the PERM, only because it's the right time for NIWs. You can actually see WR podcasts and also webinars on this, and it'll go through a more detailed assessment of how we actually assess cases. The elections are coming up, as everyone knows, in November. So the immigration policies may change, of course, depending upon who comes in to the administration. So if you have any individuals that you want us to assess, please feel free to reach out to our office and contact us, and we're happy to do an assessment. And then we can go from there on the national interest waiver. Again, you can premium process them 45 business days. So it's a really good option right now for a lot of those who are stuck in the PERM processing queue. All right, Charlie, this is a question for you. How much coordination is there between the Department of Labor, Department of State, and USCIS on the visa bulletin?
There is a lot of coordination between USCIS and the State Department. I had minimal involvement on a monthly basis or a regular basis with Department of Labor because they're at the front end of the process. The reason it is so important to deal with USCIS is because they have the actual petitions and can provide information on the amount of petitions that they see coming forward in the future months and the amount of adjustment of status applications which have been received, which would potentially require the use of a visa number in the coming months. So again, there's very close coordination between the State Department and USCIS in the determination of the monthly final action dates, and also in the establishment of the application filing dates, which are listed in Chart B, with typically the application filing dates announced in the month of October are typically the biggest changes in those dates.
Yeah, but then there's a tweet that was, or I don't know what you call a tweet. Is it a tweet still? About um, 12 analysts do perm applications full time. They average actions 50 a day. That's 12,000 a month. And yet they claim it takes 396 days to decide a perm application. So I think there needs to be some sort of coordination, because that can, I remember you and I were speaking to one industry, and they were having all these questions about why was there a spike in I-140 during a certain time period. And what we did is we looked back at the DOL statistics to see whether there were spikes there, right? Because we could see then how many perm applications were submitted by DOL. And that's where we actually saw the spikes, right? Was because there are actually more DOL applications being submitted under the perm.
Right. But the more of the interaction would be DOL and USCIS.
Yeah.
That is the more important. In terms of states' concern on the visa bulletin, it would be USCIS and state coordinating that, because the fact that the Department of Labor may have X amount of cases, that is not pertinent to the actual use of visa numbers in the current year. That the Department of Labor, quote, backlog will impact visa availability in a future date, but there is no idea, like you said, is it going to take 12 weeks? Is it going to take 12 months, or going to take 2 years for those to be processed, potentially resulting in the need for a visa number in the future? So again, that's why state talks to USCIS mainly, to know what USCIS actually has in terms of petitions that they're working on, either to adjudicate or have already adjudicated and are in the pipeline competing for a visa number in the coming months.
Okay. Well, thanks for that feedback, Charlie. Any final thoughts to share today?
No, again, we mentioned, the June visa bulletin indicates that there will be likely retrogressions of the rest of world employment's second and third preference priority dates. Therefore, if you have an appointment in June or May, be sure to attend the interview.
Okay, well, that wraps it up for us today. We hope you enjoyed tuning in and the questions we've answered. If you have any questions you'd like us to answer in the next Bulletin podcast, please submit them in the survey link in the description, and then we'll address it then. Again, if you have any one-on-one consultations you'd like to do with Charlie about your specific industry, please also reach out to us, and he can provide some guidance on what's happened in the past, the trends, and then future predictions. And please also share any feedback and suggestions for us. Thanks again, Charlie, and to everyone who tuned in today. See you next time.